So without further ado, could we give a big St. Ed's welcome to two alumni and Supreme Court lawyers, Bob and Steve.
Thanks to Jack and his team for putting this event on and for inviting us here today. And thank all of you for giving us a little bit of your time today for an issue that's very much of import to me and Bob, obviously, in our practice of law, but also, we believe, for the United States and actually for the rule of law in international law. And that's one of the things I'm going to talk about today. Then Bob's going to talk more about the specifics of the case and the argument and so forth. I'm going to try to situate this specific lawsuit within the context of U.S. law and the development of international law. So let me start with the event itself. On June 7, 2010, a group of Mexican boys on the Mexican side of the border outside of El Paso were playing a game. The game was, let's torture the Border Patrol agents in the United States. So the international boundary outside of El Paso is the middle of the Rio Grande River. Well, anyone who knows El Paso in the summer knows there is no river. If anything, it's a trickle of water. So somewhere in this dry culvert, just outside of El Paso, is the international border. And what these boys would do, they get off from school and they would run up and touch the fence that's on the northern side of the international boundary, a game of chicken. And they would run back down and run back into Mexico. Well, along comes a U.S. Border Patrol agent, and he grabs one of the boys. And you'll see in the video that Bob's going to show you exactly what happened from there. And unfortunately, this Border Patrol agent, I still don't know to this day what was going through his mind. Nobody knows what was going through his mind. I'm sure they have a very, very difficult job. But unfortunately, the Border Patrol agent, while standing on U.S. soil, shoots his gun into the crowd of boys on the Mexican side of the border. They've now retreated back into Mexico, fires into a group of boys, kills our client, the child of our client. We represent the estate, the mom and dad of this boy, Sergio Hernandez, 15-year-old boy who was shot and killed. The legal issue is a real narrow one, and that is, does the rule of law still apply when there's an international, literally an international, between nations incident? The Border Patrol agent is hired and is in the service of the United States government. He is standing on U.S. soil. He fires across the international boundary into Mexico and kills a Mexican citizen. Now, there's one thing you need to know, and that is, if this incident had occurred solely on United States soil, that is, if Sergio had been 30 feet to the north in U.S. territory, there's no doubt what would happen legally. That is, the parents of Sergio would be able to come into a United States court and ask the federal judiciary, the U.S. judiciary, to review that incident to determine whether or not that was a justified shooting. Was the agent justified in shooting in these circumstances? What circumstances justify shooting a 15-year-old boy or anyone else? The law is very clear, both in the United States and throughout the developed world. A police officer can use deadly force only if he or she is in imminent fear of death or serious bodily injury to himself or to another. That's the standard, and it applies throughout the developed world. And the rule of law consists in checks and balances. You've all heard this phrase, checks and balances. The check and balance here is you have a member of the executive branch of government, a U.S. Border Patrol agent. Okay, that's the executive branch. Works ultimately under the direction of the president. And what happens is we say the rule of law is the executive doesn't get to go around killing people, especially civilians. There may be other rules that apply in a military context, but this is a civilian domestic police agency. And the check and balance is the federal judiciary, U.S. judiciary, then reviews any shootings, use of deadly force by the executive branch of government so that you have one branch of government acting as a check on another. Now, during the course of that check, there will typically be a lawsuit, and the agent and the U.S. Border Patrol can come into court and say, it was a justified shooting. In this incident, I'll tell you that the FBI put out a press release the day after this event and said this was a justified shooting because these kids were not kids playing a game. They were human traffickers smuggling people into the country, and after the agent got the one boy on the ground, he was surrounded by these human traffickers, and they were pelting him with rocks. That's what the FBI put out a press release the next day saying that happened. But we live in a world of cell phones and cell phone videos. So the day after the FBI press release that falsely said what happened, of course, the cell phone video surfaces. A woman had been on the Paso del Norte, and she took a video of what happened, and it shows the agent is not surrounded. There's no one throwing rocks at him. And, to this day, you look at that video and you say, what did I just see? I just saw a Border Patrol agent take out his gun for no reason and shoot it into a crowd, and he killed someone. That's what happened. So, the legal principle is a straightforward and very narrow one. Does the rule of law apply? The rule that I told you would apply if Sergio had been in the United States apply if instead he happens to be 30 feet across the border into Mexico? Or does what the U.S. government claims in our lawsuit is no law applies, that the executive is free of any constraint by any other branch of government, and if they want to shoot into Mexico and kill Mexicans, they're perfectly free to do it and nobody can say a thing about it. That's their position. We say no, the rule of law still applies, and Bob will get into some of the details as why that is. That's the issue. Now, I started off by telling you I'm going to conclude that the government's position here is a betrayal of the United States' leading role in development of international. So, 1789, the Bill of Rights is proposed as a result of the Revolutionary War. What law do the Founding Fathers ask the country to ratify? That no person shall be deprived of life, liberty, or property without due process of law. Now, due process of law often means in advance of something happening, the government has to go in and say, well, we want to take your house for eminent domain. There's a proceeding before the event, before they take your house. Obviously, when there's a killing or a shooting like this, the process can't come before, it comes after. And the process to which people are due comes afterwards, a court reviewing whether or not the executive's conduct was lawful. So that's 1789. 1866, after the Civil War, there's an early draft of what becomes the 14th Amendment to the U.S. Constitution that's applying this concept of due process of law to the states. And the early draft says, no state shall deprive any citizen of life, liberty, or property without due process of law. That was the early draft. But I'll get to the person who changed that. The final text says, no state shall deprive any person of life, liberty, or property without due process of law. So there was a conscious decision to say, we're not going to, in this country, limit these rights to only our citizens. We're going to consciously expand this to say we're going to extend these protections to every person, whether or not they're a citizen of the United States. I'll read the key parts of this. That's small print. But there's a man named John Bingham, who's a very interesting man. He's the person who changed the word citizen to person. And here's why he said he did it. He says, the great men who made the Fifth Amendment, that's the one we just looked at, when they undertook to make provision for the security of the universal rights of man, abolished the narrow and limited phrase of Magna Carta, the English Bill of Rights, which gave the protection of the laws only to free men, that is, to citizens, and inserted in its stead the more comprehensive words, no person, thereby obeying that higher law given by a voice out of heaven. And this is a quote from Leviticus: you shall have the same law for the stranger as for one of your own country. Thus, in respect to life and liberty and property, the people by their Constitution declared the equality of all men, and by express limitation forbade the government of the United States from making any discrimination. Your Constitution, he's referring to the Fifth Amendment, says no person, not no citizen, shall be deprived of life, liberty, or property without due process of law. So that's where we were after the Civil War. Along comes the Second World War, the Universal Declaration of Human Rights, the first international declaration of the rights of people. And it says, Article 3, everyone has the right to life. Article 8, everyone whose rights are taken unlawfully has a right to an effective remedy. That is, there's going to be judicial review of the taking of these rights. And I'll tell you, most of you probably know the history of this, but Eleanor Roosevelt, on behalf of the United States, played a leading role in the development of the Universal Declaration of Human Rights. The United States was the leader in developing the first instrument of international human rights law. Then, in 1966, there is proposed the International Covenant on Civil and Political Rights, where now these rights that are declared in the Universal Declaration of Human Rights are now going to be made effective law. And they say the same thing. You got a right to life. You've got a right to go into court and have those rights sustained. Now, President Carter, who was in office when he asked the Senate to ratify the International Covenant, said that that covenant itself is not going to be enforceable law in the United States courts. But why? Why did he say that? He says, we don't need to have the International Covenant on Human Rights be enforceable in the United States courts because our own domestic law already gives everyone all of those rights. So it would be redundant. Now, that's the U.S. leadership in international human rights. You noticed I put the years and which war these instruments were associated with to indicate how hard-won these rights are. It took a war to get these rights. And now what's happening is, in a time of fear, the United States has a tendency to retreat from the international rights to which it's a signatory and in which it is a leader. And we think that what's going on in this lawsuit is simply another example of that phenomenon, where the United States is a leader in human rights, establishing these rights. Then something happens in this country, whether it be detainment of people of Japanese ancestry during the World War II, the Chinese Exclusion Acts, whatever else it is, but in a time of fear and uncertainty, we have a tendency to retreat from the rights that we ourselves have promoted throughout the world. One thing, this case and the U.S. government's fighting us on the establishing this right occurred not under the Trump administration. It's being pursued under the Trump administration. This is an Obama-era lawsuit. And it's this point about fear, because I've asked the Assistant Attorney General why, during the Obama administration, why are you fighting us on this case? This is a no-brainer. The 15-year-old boy, 30 feet outside the United States, a domestic police agency. This is a routine case, or should be a routine case. Why are you fighting us on this? And it's the war on terror. Because when you articulate the right that we're trying to establish, the right of a non-U.S. citizen killed or injured outside the United States by the federal government, the ability of such a person to come in the United States courts and challenge the executive's conduct, you can see right away what the problem is. The jihadi killed on a battlefield in Afghanistan will be the next plaintiff. They'll come into court and say, we want to review the drone strike that killed our son or that killed our daughter. And the government doesn't want that to happen. And we, of course, say, what's a drone strike in Afghanistan and the military conflict have to do with a 15-year-old boy 30 feet across the border, a citizen of Mexico, one of our friendliest neighbors? What's that have to do with the battlefield in Afghanistan in a military conflict? And they say, we just don't want to open up the floodgates. So this element of fear is also connected to a lack of confidence in our own institutions. That is obviously a federal court should be able to distinguish between those two circumstances to say we are going to allow a Mexican citizen killed just across the border by a Border Patrol agent who's standing on U.S. soil and who is a domestic police officer. In that circumstance, we're going to allow review. We're not going to say today what would happen if the jihadi from Afghanistan, who's killed 3,000 miles away by a drone that's operated from Bergstrom Air Force Base or anything else, whether that person gets to come in Bagram Air Force Base, whether that person gets in to come into court and review. So it's fear coupled with a lack of confidence in our own institutions. So turn it over to Bob.
Good afternoon. I'm Bob Hilliard, Steve Shadowen's St. Edward's roommate, Doyle Hall, 3rd floor. We've been together since 1977. What I would like to do is take you on a road less traveled in regards to what Steve started with you, and that is he began by telling you something about how the intellectuals, and Steve is really one of St. Edward's, not only St. Edward's, but one of our country's great intellectuals. This is a head-scratching issue for those who understand the history of the law in this country. This is one of the issues where they say, how can we even have to go to the United States Supreme Court and say cops can't shoot kids and not have their conduct reviewed by courts of law? Why are we even doing that? I come at it from a practical standpoint. You know, my background's different than Steve's, but we complement each other, and I think that's why we did it so well together in D.C. I come at it from a position of persuasion, of saying, okay, I have to tell the United States Supreme Court why Steve Shadowen and others like him and those that wrote our briefs are saying this is the slipperiest of slopes. If you do this, you are going to find that the knock on the door tomorrow will be the door at your house. It will not be Sergio Hernandez, who speaks Spanish and who is 30 feet away from the United States and whose mom thought he was coming home for dinner that night. it will come on this side of the border. So to give you a visual perspective of how stunning and how stark a murder of a Mexican boy is, because what you're about to see is the video taken by a woman from Alaska. And this woman was on the bridge, married to a Mexican national, coming across. She turns on her video camera when it starts to unfold. After Sergio is shot, literally between the eyes, the Border Patrol come up on the bridge and try to run all of the Mexican nationals away, so there will be no witnesses. And she stood her ground to armed Border Patrol agents yelling at her, and she said, "No, I'm not going anywhere." But my explanation is included in this 4-minute video, so I'll turn that on, and then I'll take you to, if we lose this case, what it means to Austin, Texas, to the state of Texas, to the United States of America, and to the young people who are here and hopefully beginning to think about what they want to do and how they want to start to stand up and say, this is a difference that I am determined I'm going to make in my life, professionally and personally. So take a look at this. So when this was going on, there was a lady on the Paso de Norte Bridge with a video camera. She was an American citizen from Alaska, and she saw it unfolding, turns on her video camera, and she's appalled by what she sees. She calls it an execution. She walks into the United States. She calls the El Paso Police Department. She calls the FBI, and she says, "I just witnessed a murder." That next day, I tell you that to tell you this, the very next day, the FBI issued a press release. Dan Mesa was surrounded by boys, being pelted with rocks, was in fear of his life, and had to shoot in self-defense. False. Completely false. I decided that I was going to go to Washington, D.C. and argue Sergio's case on behalf of his family. When I got a call in 2010 from a friend of mine who's a lawyer in Houston asking me to take this case, I listened to the facts, and the facts violated a code I have, and that code is, this just is not right. If you have a U.S. Border Patrol agent standing inside the United States, he shoots across an invisible line, and he kills a Mexican national standing in Mexico, non-threatening, unarmed. And this was a son of Mexico, standing in Mexico when he was shot. When he was killed. There's 6 dead Mexican nationals already who fit this fact pattern. In Mexico, in their own country, shot from the United States, no constitutional constraints on the officer who shot him. The deaths start in San Diego, they go to Arizona, they go to El Paso, Laredo, and then Brownsville. So they're along the entirety of the southwest border, which says it's not peculiar to El Paso, where Sergio died. It's from one end of the border, literally, to the other end of the border. The former head of the Border Patrol who says, look, we hired so many people so fast, we trained them so poorly, that there are some in there that are bad apples. That's just a fact of the way we did it. You know, we're 44,000 strong now, with the biggest single law enforcement agency in the country. Today, the court heard whether or not U.S. border agents standing inside the United States can shoot across the border and kill Mexican nationals. It's an important question right now, given the current climate that's going on. This is President Trump's Border Patrol. He has said that he is going to increase the number of Border Patrol officers, and that he is going to instruct them in regards to what to do on the border. Our position today is it is up to this court behind me, the United States Supreme Court, to check the executive in regards to the constitutionality of those actions. I think the court today understood that there was a separation of powers issue, and that it didn't make sense that if the officer had shot right on this side of the border there would be a constitutional constraints, but not right across the border. The amazing position is that while a U.S. law enforcement officer stands in his own country, his own constitution that he swore to abide by and comply with turns off, and he doesn't have to worry about it. And he points his gun feet across the border and he kills an innocent person. And there are no consequences except what the executive decides should be the consequences. It's remarkably dangerous. You know, the courts are the bulwark to protect the people from the conduct of the executive, from the conduct of the White House. You know, it's the Supreme Court that decides what the law is, not the White House. It's hard to believe, right? It seems like it would be an ethics question in Professor Zanardi's class, a hypothetical. It's not something that you would think really happened. I went down to the border and I stood where Sergio stood when he was shot, and I was trying to get my head around what was it like to think that there's a law enforcement officer who decides that he can shoot someone. So what I'd like to do is two things. I'm going to first talk about Steve and I and how we decided together to do this and our passion for it, and then our preparation. And then I'm going to talk some to you about, okay, we've done our part. We went to the Supreme Court, you know, we called BS, and we'll see what they do. And they're going to do it in June. Now what my next request is what's your part? What are you going to do? Because it doesn't just end with the Mexican nationals being shot on the border, as you will hear from Sonia Sotomayor, who asked a straight-up question that we captured the audio from, so you can hear it. But back to Steve and I. So what we decided to do a couple of years ago after we graduated from St. Ed's and started our lives separately and professionally is that we would form a law firm here in Austin, Hilliard and Shadowen, and we would do cases that mattered. We would take on only the cases that we used to talk about, you know, in the unair-conditioned room of Doyle Hall, and think about and be inspired to consider by the professors here. And so we started a two-man law firm. I had my own firm in Corpus. He was part of a very big and successful firm in Philadelphia, Harrisburg. And we started to look for cases that mattered. And so we took this case on. We're about to take on big guns because I don't believe that anyone needs an assault rifle at any time. And that litigation on behalf of the victims of Orlando is a conversation Steve and I go have after this talk. But it's those types of cases that we decided to take on. And when you make that decision, it's not as if people come around you and say, we support you, you're doing the right thing. It's a lonely decision to stand up and say, you know, the president has no clothes, or the United States government is wrong when they're standing on the podium next to me saying they have a right to shoot Mexican nationals, or the gun manufacturers who say they can sell assault rifles at trade shows down the road on South Congress with no background checks. You know, what's right sometimes is not going to be what the crowd around you is going to tell you is right. It's going to be what you think is right. And the fear that is going to come with that decision is you're going to go against, you know, the institutions. You're going to go against powers. You're going to go against money. And you're going to be overwhelmed and afraid. And that's a natural part of the process, waiting for the U.S. Supreme Court to tell us whether domestic law enforcement officers don't have to abide by the Constitution, unconstrained, and they can kill kids. That's what we wait for right now. And you know, if you'd have told us that 10 years ago, 15 years ago, I wouldn't have believed it. So the Supreme Court grants cert, and Steve and I start getting ready, which means Steve starts trying to get me ready as best he can, and he did, you know, as my best friend, he did a great and powerful job. The week before we went to oral argument, we went down to D.C., we got a conference room, and for 10-hour days sometimes, we were just down there by ourselves. I was at the podium, he was firing questions. And finally, I had to tell him that, listen, Steve, if you say you know this answer to me one more time, you're going to be picking yourself off the ground, man. But we combined our love for the law, our love for each other, our passion for what we do, and we created, I think, for two guys that have never done that, I think we did a good and honorable job. I think we did it right, and we hopefully will succeed. So then, as I thought about what I'm coming here to talk about, as the invitation in regards to ethics, young people who sit where Steve and I sat, seems like yesterday, wondering what should I do, I then start to consider what's going on in Austin, what's going on in Texas. And I'm going to move you away from the Hernandez case, and I'm going to move you into something that is very concerning to me. And I'm going to tell you why. How far is it from House Bill 4 to bullets on the border? House Bill 4 being considered right down the road where hopefully someone here went yesterday and protested. If not, you can go tomorrow. House Bill 4 says it is illegal for local law enforcement officers to refuse to detain someone if that someone does not have the ability to show proof of citizenship. It is profiling, as you will see by the statements of your chief of police in Austin, your chief of police in Dallas, your chief of police in Fort Worth, and your chief of police in Houston. And the reason that I put that stark picture there is because if law enforcement have the permission, the internal permission to think they can shoot Sergio, I'm telling you that they won't hesitate to turn around and see someone similar to Sergio to their north. That officer was standing to the south. He could turn to the north and he could see someone that he decides is a Sergio. If Sergio's death is not a constitutionally protected incident, then the next step, which we're now looking at with House Bill 4, because it all happens in small steps, right, Bill? I mean, you don't suddenly wake up one morning and say, we've suddenly been taken over by a totalitarian government. You wake up one morning and you say, hey, there's a House Bill 4 that's telling police officers they're going to get arrested if they don't detain someone whose skin color makes that person susceptible to being a Mexican or a Muslim. Sanctuary cities is what they call the House Bill 4. It's tried to eliminate sanctuary cities. Every San Antonio police chief, officers will start inquiring about the immigration status of every person they come in contact with, or worse, only inquire about the immigration status of individuals based on their appearance. Next one. Your Austin chief. This will lead to distrust of police, less cooperation from members of the community, and will foster the belief that they cannot seek assistance from police for fear of being subjected to an immigration status investigation. Next one. Houston Chief Police. When it comes to criminals, we are in this together, regardless of race, sex, religion, or nation of origin. SB 4 will make our communities more dangerous, not safer, as we presume the legislature intended. So real consequences. I'm going to tell you, my wife Catherine is on your board of trustees. She's sitting here to my right. She is a Mexican American. She's a proud Hispanic woman. We have children together. She brought one child into our marriage, Ali Danielle Salazar, who I've raised since she was 1. She's president of her student council. She's an amazing debate champion, and she's an advocate like you wouldn't believe. But in thinking about House Bill 4 as it relates to me, I want to show you a picture of Allie and her sister. So that's my wife, Catherine. That's Allie to the left. And that's our daughter, Tobin Grace, who's Weta. And so I was thinking, okay, so under House Bill 4, Allie and Tobin are driving their bike down the street. If they're detained for whatever reason, or Catherine's with them, under House Bill 4, if Catherine and Allie cannot show proof of citizenship, Tobin gets to continue to ride her bike and they get to be detained. You know, and with whatever power I have, I know that I don't need to wait until that incident happens to the people I love to say, I'm not going to allow this to occur if I have something to say about it. And my point is to bring home to you, many that I look out on this audience at have skin that might cause you to be stopped and you to be told, we want to see proof of citizenship. How insulting to you, to your family, to your education, to your passion, to your citizenship of this country, that you have to prove that. What a false narrative. All right, so I'm going to conclude by giving you a piece of, I'm taking you back to the argument because she gets it, you know. Sonia Sotomayor understands the danger here, and she's not one to parse words, she's not one to hide behind, a case or language. She wants to get to and cut to the truth of what she sees is going on. So listen to how she talks to the U.S. government's attorney and what she says.
The U.S. government is suggesting that anyone is condoning people standing at the border and taking pot shots and passing Mexicans. Wouldn't shooting pot shots at Mexican citizens be shocking to the conscience?
Of course it would. But the U.S. government paid their Solicitor General to stand up and tell the United States Supreme Court that it was reasonable, that the Constitution does not apply in that situation. And the transition from that into Senate Bill 4, or the Senate Bill 4's comparable bill in Arizona, or the one they're considering in one other state that I read about today, it's interconnected. The last... Go ahead. So let me set the stage for that last slide. And so in their rebuttal, the one hypothetical I wanted to leave the Supreme Court with involved how the government's position just didn't make any sense based on the invisible line when the conduct is exactly the same. And this is the last thing I told them before my time was up and I sat down.
Most of my friends on the other side have now said there's a witness claim for the boy who shot next to the officer. Take that position into this hypothetical. The officer shoots the gun and the bullet leaves the gun. There's constitutional consequences if the bullet travels all the way to the border. If there's a boy between the gun and Sergio, and that bullet goes through that boy in the U.S., and then the same bullet hits Sergio, their position is that there's a Bivens claim and there's a constitutional constraint as to the first boy who dies, it's not the second boy that dies. The conduct occurring in the United States, 100% of it, if it gives a Bivens claim, if it gives a normal standard Bivens claim to the boy who shot somewhere with the bullet and then it does not give one to Sergio Hernandez, it ends up being anomalous.
I'll leave you with this idea. There will always be Bob Hilliards and Steve Shadowens ready to stand behind you, you young soon-to-be graduates here, if you decide that there's a cause that you want to take on. You know, there will be folks like us who will help you as you learn your own power. But I encourage you, and I encourage you to share your need with your friends that you don't need to wonder, where should I go and what should I do? It's a mile away. It's right down there at the Capitol today on South Congress. It's Senate Bill or House Bill 4. You know, building blocks of courage and building blocks of life decisions, you know, create your tapestry. I would tell you now that if you can, if you want to, if you feel inspired to do so, make a sign. Go down there. You know, you don't have to be arrested. You don't have to tell a police officer to, go to hell. You can simply say, I am voicing my dissent, which is my right under this Constitution. And then come back and do whatever else next you feel you have to do. Jack, thank you for letting us come here. Thank you very much.
Anyone have questions for either of them about the case, its implications, what the ledge is doing right now, which isn't too far afield from the actual case itself, sadly speaking? Anyone have, I have plenty of questions, but I'd rather, and I have a mic, so I can bring it to you, and you go ahead and tell which one you want to ask.
Hi, my name is Gamu, and I have a question for Steve. So you mentioned that, the reason why they don't want to go through with the case is that they're scared that other countries will be able to sue the United States for debts. But there was a case I heard on NPR where a U.S. citizen actually sued another country for the death of his daughter when he was there. So I don't understand how, U.S. citizens can sue, like, Iran because, they're a sponsor of terror and that killed their daughter. But, a Mexican citizen can't sue the U.S. for the same thing. That's it.
Thank you for that question. I talked about the U.S. government's position I talked about the U.S. government's position in this case being one of betrayal of the United States leadership with respect to international law. But the question points out another aspect of this case, and that's hypocrisy. The United States opens its courts, its federal courts, to human rights violations that are committed by citizens of other countries against citizens of other countries that occur in other countries. If there is some connection to the United States, let's say that a U.S. corporation is involved, or let's say that the defendant happens to be traveling to New York for a convention and is being able to be served with process while he's in this country. A person, a defendant who committed an act just like this in another country and is a citizen of another country and killed a citizen of another country can come into the United States courts and have the United States courts determine whether or not that conduct violates international law. The U.S. is the cop of the rest of the world, and rightly so. But how in the world do we then justify not opening our courts to review the conduct of our own Border Patrol agents for conduct that occurred in the United States against a friendly national 30 feet away? So thank you for that question.
Let me add to that for a minute. I'm going to add to that very quickly. So what the government decided to do in this case is take a position, the reason for it being terrorism, and say, even though that's the reason for it, we have to pretend that we have a real problem with Sergio Hernandez coming into the United States seeking justice. So much so that they said that the police officer had what's known as qualified immunity. That means, and they argued that there was no case law on the books that told a Border Patrol agent that it was unlawful to shoot Mexican kids. So he wasn't put on notice that his conduct wasn't allowed, so how can he be held to that standard? So think about that. That was an argument made in their briefs and in the Fifth Circuit. And at the Supreme Court, thankfully the court didn't even bring it up. I think that's a throwaway issue. I think they knew that that's like, come on. Right from wrong is right from wrong, and you're shooting kids, you're not writing contracts. But the problem is that the real reason to appeal the case, as Steve said, was not because they don't want Sergio coming in anymore. Their fear is unrelated to this kid, and they're willing to throw him under the bridge, so to speak, in order to protect their bigger plan inside the world.
And I had a question about the bad apples, so to speak, about that we find in our officers on the border. Was there any statistics or evidence given on either side as to the degree of, the bad apples, and if there was it used as an advantage or disadvantage for either side?
So the former head of the Border Patrol wrote a friend of the court brief, and they laid out the statistics on shootings that should not have occurred and on conduct that occurred because of their lack of training. And he set out pretty objectively why they have poor training, and he blamed it on the increase after 9/11. So yeah, the facts about why the Border Patrol needs improving were laid out in front of the court in briefs filed by people who were interested in this, and that included the former head of the Border Patrol, and it also included the National ACLU. It included the government of Mexico. One of the United States' position is this is Mexican sovereignty. We would be interfering with Mexico if we let their citizens come in and sue us here. And the government of Mexico filed a brief and said, what interferes with our sovereignty is when you shoot our kids. We have no problem. We have no problem with the victim coming to the United States. In fact, this officer was indicted in Mexico for murder, and the United States refused to extradite him. The Mexican Constitution protects the Border Patrol agent from being tried absentia. So their Constitution provides protection to the guy that shot Sergio and says unless he comes to Mexico, he can't be tried. He has and enjoys constitutional rights under the Mexican Constitution. Think about the dichotomy of that, because Sergio Hernandez, seeking protection under the U.S. Constitution, is deprived of those rights.
Any other questions? Yes.
Hi, my name is Allison. You mentioned that this wasn't an isolated case, that there was, I think you said 6 other cases where it was a Border Patrol officer that shot a Mexican national across the border. What happened with those? Because I don't think I'd ever heard anything about them. And one of those cases actually happened where I'm from. I'm from the Valley. And I never heard about the one that happened in Brownsville. Were these just all swept under the rug and just, it was the same old, well, they tried, was there actual innocence, or was he never trialed? What happened with these other cases?
Back to across-the-border shootings, our firm, in addition to the Hernandez case, represents families in 4 others, including ones in San Diego, Laredo. This was a brand new area of the law. Until we brought this first Hernandez case, no one thought it was even possible to try to bring a lawsuit like this, so lawyers were not interested in bringing the cases. We signed up a number of cases because we decided, as Bob said, this ain't right. We're not going to do nothing. So we brought a series of cases and we've sort of lined them up. One of the things you do as a lawyer tactically is decide which case to push forward first. And we took the one, where there's a cell phone video showing there were no rocks being thrown. It's a 15-year-old boy, and you look at the video and say, my God, I don't understand what I just saw. We brought that as the first case. If we win this case, then it's full steam ahead on these other cases. And already, Bob mentioned for the young people trying to do something in the world, you don't have to win the cases. We desperately want to win this case. We think we should win it and might well win it. But already we forced the resignation of 2 of the top 3 officials within the Border Patrol Agency. We forced the Border Patrol Agency to adopt a new standard specifically with respect to when agents either are in fact being subjected to rock throwing or claim that they are being subjected to rock throwing. There's now a new written policy. There's new training. All of that resulted from our lawsuit plus the efforts of human rights groups that worked with us, and we worked with them. So it's really important to establish the legal principle. We intend to do that. We intend to win and then pursue these other cases. But it's also good to step back and say, you know, just the filing of the lawsuits where we pounded them in the press, got an early win in one of the court cases. We forced the resignation of top officials, got a new policy, got new training, and that's important.
We have another 10 minutes. Any other questions? Everybody, including non-students.
Hi, my name is Caesar, and I wanted to know how you feel your experience here on the Hilltop prepared you for your legal career.
We were defendants in a number of cases early on.
So one night, I told Steve, you know, we need to do something about the Ayatollah in Iran because they had the hostages, and that was a big deal during our time. So we were pretty well known on campus. We held some of the student offices. And we decided in the safety of our dorm room that we would create a huge sign that said what we thought. And we would hang it from Moody Hall. And so we got paint, we got a big sheet, we wrote out the sign, we snuck up to Moody Hall in the middle of the night, went up to the top, we hung it over the edge, and we went home. And it had its intended effect. It made the papers, and they looked hard and long for who did it. And we weren't prepared to become known advocates at that time. But the point is, my education, and I know Steve's too, at St. Edward's, gave us permission to learn who we were and what was important to us. You know, I see some professors here. I know there's some professors that are no longer with us that I can still recite verbatim what they said, what their philosophy was in regards to the world, in regards to right and wrong. And though I was too young to understand it, you know, it seeped in, and we felt protected enough and permission enough to where, as that's budding, as we're learning about ourselves, that we did something that may have gotten us expelled if we would have found out about it. But I attribute it, and the reason I came back today and was honored to be invited is because, you know, this was the genesis for me of the beginning of what I wanted to do, and this started my path of understanding my own courage to do what I think is necessary. And I met lifelong friends who felt the same way. You know, and so we began to move down our path, and there's other St. Ed's graduates our age and younger who are doing similar things around the country. And it is because of the castle on the hill. And I say that often, and I believe it in my heart of hearts.
Let me kind of follow up on that.
Yeah, please.
I'll put it in a nutshell. You feel idealistic. You're not wrong to be idealistic. And the key is to take those moments of inspiration and idealism and to turn them into a lifetime of civic engagement. That's the key. Now, what are you going to do specifically? You do what you get a chance to do. Life is a lot of random stuff. This case came in as a personal injury case in our Corpus Christi office, and Bob and I looked at it and said, that's not a personal injury case. This is an international human rights case. But it was random that it came in. So keep your idealism. That's who changes the world. Take those moments of inspiration, turn them into a lifetime of engagement, and do what you get a chance to do.
Hi, my name is Eliza. Excuse me. I just wanted to understand from your points of view how being an attorney and bringing a case to the Supreme Court felt to you and how it was different from the lower courts, and what changes needed to be made throughout the process, if any?
So I am a trial lawyer and have tried 100 cases to juries, which is more of an advocacy. I'm trying to convince people of my position, and they're neutral. The Supreme Court really doesn't have any need to be persuaded. They each know how they're going to vote on the issue that comes in front of them within reason. One or two is willing to be swayed, depending on what you say. What I learned in the process is there's become a small group of people who call themselves Supreme Court specialists. They can do it and no one else can. And no doubt they can do it and they can do it well, but my takeaway is that anyone that wants to be a lawyer should have a right to take their case, his case or her case, to the United States Supreme Court. They shouldn't have to take it all the way to the Supreme Court and then say, now I have to turn it over to someone else. If you decide you're going to be a lawyer, if you decide one day that you're going to represent someone and that person's case happens to go to the U.S. Supreme Court, why can't you be the person standing in the podium and looking at those justices? The case came to you, you cared about it, you defended it, you wanted to help someone, and now you have a right and a voice that will ultimately become stronger because you're there. You know, I mean, I knew when I stood at that podium that, you know, there's guys that could do it better than I can, but I'm going to do this because the guy that hires me in a year is going to need what I learned and how I improved because of it, and I'll be ready. And so that's my view of it.
Okay, let's give them another round of applause. Thank you so much.